Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, Karen Reed's attorney needs to keep his hands to himself. And will Lori Vallow get her trial in Arizona this August? Can you imagine asking a 19-year-old to get a job, and the result is that he kills you? Will an accused murderer walk free because of the statute of limitations? Is Amazon becoming the new post office? More school misconduct. Guess what these two ladies did to get in trouble? And an example of the gun just going off. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. All right, it is July 3rd, 2024, the day before my favorite holiday, Independence Day, July 4th. I love it. Anyway, let's get to the docket. First, Karen Reed's attorney may want to keep his hands to himself. It just looks weird. As some people are saying, is that attorney-client privilege? Anyway, take a look at this photo. Karen Reed was spotted cuddling up with her attorney, Alan Jackson, outside of a high-end Boston steakhouse last week as jurors were deliberating Miss Reed's case over whether she murdered her former Boston cop boyfriend back in 2022. Now, this iPhone Live photo appeared to capture Mr. Jackson, a criminal defense attorney from Los Angeles, wrapping his client in an embrace with one arm around her midsection and another tightly across her chest. Now, this photo was apparently taken on June 27th outside Smith and Walensky's in downtown Boston. Now, the clip only lasts 1.5 seconds, but it appears to show Miss Reed, and she's smiling as Mr. Jackson, who notably had a wedding ring on, grabs her while they watch two other people pose for a photo outside of the restaurant. The video has apparently been verified by metadata of the original photo, and it shows that it was taken in the area of the steakhouse on the 27th when the jury was deliberating. The person who took the post, although they were remaining anonymous, said, quote, "I was eating dinner with my wife, and I happened to look out and see them outside. And it looked a little wrong and inappropriate, so I just grabbed the closest phone and took a picture." There it is, ladies and gentlemen. The picture taker noted as well, it was just her attorney kind of, I don't know what you would call it. It looked inappropriate for an attorney-client type situation. So what we do know is the photo was taken at Smith and Walensky, where Reed and Jackson were apparently earlier photographed dining with members of the legal team. And they were wearing the same outfits, apparently, from another photo in the alleged embrace photo. Now, the photo was also published on X by an account called Masshole Mafia, run by Kate Peters, who has stated that she was the one who obtained the shot. Now, Peters has been vocal in her belief that Karen Reed is guilty of killing Mr. O'Keefe and runs the account as one of several partisan social media pages that have cropped up in the wake of the high-profile investigation. Now, Mr. Jackson is married. He's married to a district attorney out in California. Now, what can I say about the photo? I would like to think that I wouldn't take any photos like that with my clients. That seems something a little bit more than a handshake. Occasionally, you'll get a client that will say, "Oh, I'm a hugger," and you give them the nice pat on the thank you. But you don't hug. And I can't imagine, nor would I ever think of wrapping my arm around the midsection of a client. I think that would cross the lines. You know, yesterday I gave you a little bit of advice that I always give young attorneys that come to work for me, is that you've never met a client worth going to jail for, and you've never been paid enough to jeopardize your law license. The other rules are, this is what any attorney can pass just about any ethics exam if they remember these simple rules. First, don't steal your client's money. 2, communicate with your client so they always know what's going on and they're aware of all the decisions that are being made or need to be made by them as well. And 3rd, don't sleep with your client. If you can master those, you have a pretty good chance of keeping your law license. Now, I'm not saying that Mr. Jackson did anything inappropriate, but sometimes perception is reality, and that would seem like it would be a little too close for comfort. I could imagine if the lovely Miss Kristen saw me wrapping my arms around the midsection of a client, I think she would say that would be inappropriate. Now, I would love to know what Mr. Jackson's wife thinks about it, but I don't think we're going to hear what she has to say. My guess is from the future, it'll be nothing more than a handshake between Mr. Jackson and Miss Reed. Next on the docket, Lori Vallow. Yes, the defendant that will just never go away. Well, her murder trial is now going to resume in 2025. Now, the decision to push back came at a hearing yesterday in Phoenix, and Ms. Vallow appeared in court in person. And as you may recall, she originally said she did not want to waive speedy trial. Her attorneys filed a motion to waive speedy trial, saying the case was complex, the discovery was quite voluminous, and that they needed additional time to prepare, engage in motions, practice, analyze the evidence, prepare a defense to be effective. And the judge has decided that the trial will now go in February of 2025. Now, as most people know that watch this channel, Ms. Vallow was convicted of the murder of her 2 children, Joshua Vallow and Tylee Ryan, in Idaho last year. And in Arizona, she faces charges for conspiracy to commit murder and a charge of attempted murder. The charges are related to the death of her 4th husband, Charles Vallow, and the alleged attempted murder of Brandon Boudreaux, her nephew. So, like I said, February of 2025. So the court has to balance a couple of things when they do something over the objection of the defendant like this. She has a speedy trial right. Now, it may become an issue if there's a conviction, but frankly, in the big picture, probably doesn't going to matter. Yes, she has a right to that speedy trial, but the court is saying she also has a right to effective assistance of counsel. And if a counsel is saying, I cannot be effective with an August trial date, the court is going to give them the opportunity to do that. And making sure that she has a fair trial probably trumps the idea that she needs a speedy trial. And given her current status, it's not like she is going anywhere. So it's not like we're saying, well, this is the only thing holding her in custody, and therefore, Judge, we need to let her out. Give her a reasonable bond if you're not going to set the trial within the speedy trial dates. So not surprised that it necessarily happened, but I expected a little more vocal objections from Lori Vallow in this particular case, but in the big picture, it really doesn't matter. Hey, is this the state of the world today where you ask your kid to clean up his room and get a job and he kills you? I hope not, but man, does this sound like a scary situation. So a 19-year-old young man, he's a man, he's 19 officially, is facing going to prison, but there's some questions about his mental health after he strangled his mother to death. So this is Connor Kobold. He's been charged with 2 counts of murder and 1 of aggravated battery in connection with the death of his mother, Chanel Burns. So back in February, police were sent to the home where Kobold and Ms. Burns lived. Burns was found unresponsive and not breathing in the living room, and Mr. Kobold confessed to strangling his mom. She was later pronounced dead at the local hospital. Well, like I said, Kobold now faces some mental health investigations over his decision of he would like to represent himself at trial and the reason he allegedly killed his mother. So apparently things have become strained between the mother and the son to the point that she issued an ultimatum to him and an eviction letter. She had given him 30 days to find a full-time job, clean his room, and help around the house. Oh my gosh, can you imagine such demands for rent-free housing? My goodness, will the demands never stop? Anyway, this is apparently what pushed Mr. Kobold over the edge, resulting in him strangling his mother. So now Mr. Kobold wants to be his own lawyer. So the judge is now asking, maybe we should do a little competency evaluation, because really you're kind of crazy if you want to represent yourself. You're 19 years old. You have no experience, no legal training whatsoever. And the court went through this inquiry and said, all right, I'm going to let you do this, but if you come back not competent, I'm not going to let you do that. And usually saying, hey, I am going pro se means one thing to the court and everybody in the courtroom. I am so guilty that I just want to ride this bomb all the way into the ground by myself, and I don't want to bring anybody else along with me. Watching somebody, particularly in a homicide case, represent themselves is painful, ladies and gentlemen, and he should be declared not competent if that's what he wants to do. Now, I know somebody that represented themselves on this traffic ticket or this case, and they won. It's the exception to the rule. As I tell everybody, I don't care whether you hire me or somebody else, but get yourself an attorney. When you go into the courtroom, the prosecutor is not your friend. They don't have a duty to say, hey, I'm going to make you a really crappy offer. And if you hold out a little longer, the offer may change. Or, hey, I don't have my witnesses to prove my case beyond a reasonable doubt. But here, take this crappy offer anyway. Prosecutors can do that. They don't have any duty to say, I'm totally taking advantage of you because you're pro se. So that's why I tell everybody, get yourself an attorney. Okay, I'm not a very handy guy. I could try being a plumber. I could try being an electrician. Do it yourself and save, right? Yeah, and then I'm going to spend more time trying to do it and then more money trying to fix up what I have created. So anyway, when the judge asked Mr. Kobold all the questions about, are you really sure you want to do this? Do you have any formal legal training? You understand this is a complex area of law and that somebody with some special training in this area could be beneficial to you. And that if you proceed pro se, you're going to be held to the same standards as an attorney, and that the court cannot assist you in any way because you're a pro se. And you have to be familiar with the rules of evidence, rules of criminal procedure. Anyway, Mr. Kobold responded, I believe my case is so unique that the only person who can explain what happened and why it happened is myself. So the judge said, all right, I'm going to understand you're making a knowing voluntary waiver of your right to legal counsel, but he's going to issue a little warning saying we're going to wait to see what the mental health exam comes back with. Interesting that his thinks his case is so unique and special. Okay, fine. Use the attorney, and then you testify as to why you think it is. But guess what? Why you think it's so unique may not be admissible under the rules of evidence. My mom was mean to me. She asked me to clean my room. Therefore, that justifies me killing her. That's not going to fly. Anyway, Mr. Kobold faces between 45 and 84 years in prison if he is convicted of the most serious offense. His trial is on August 6th. I hope this would be televised. This would be a great example of why you get yourself an attorney. Next, is this guy going to walk free because of the statute of limitations? So, ladies and gentlemen, most crimes have a statute of limitations. The exceptions are usually murder, forgery. You wouldn't think that, but forgery usually has no statute of limitations because let's say if somebody forges a document and it comes to light 10, 20 years down the road, you didn't know about it. So you have to know about it. Usually the statute of limitations starts when you know about it. Each statute of limitations differs. I can tell you here in the state of Colorado, for most felonies, it is 3-year statute of limitations. For most misdemeanors, it's 18 months. So from the date that offense occurs, if you're not charged within that time period, 18 months or 3 years, that's it. Most federal charges are 5 years. The statute of limitations, there's exceptions to those. Here, for example, murder, usually unlawful sexual assaults have no statute of limitations because sometimes people don't come forward on a sexual assault for years because they have repressed those memories. Obviously makes it very difficult for both the prosecution and the defense when you only have a he said, she said type of situation, but that is reality. So most cases have that, like I said, with the exception of murder in most jurisdictions. So a little bit of a situation happened the other day in a court appearance for David Smith. Now, he went back to court because they were going to argue for a bond reduction in regards to his murder case. Now, Mr. Swift was accused of killing his wife, Karen Swift, back in 2011. Now, one of the issues that was raised in the argument for the bond reduction was, in fact, that the statute of limitations had run on one of the charges. And so the hearing turned into a motion to dismiss based upon the statute of limitations, saying that it expired prior to his 2022 indictment on one charge of voluntary manslaughter and aggravated assault. Now, last month, why this becomes significant is a jury was hung on the charges as to whether David killed his wife, Karen. The jury found him not guilty of first-degree premeditated murder, so that's gone. Not guilty of attempted first-degree premeditated murder, gone. Not guilty of second-degree murder, and not guilty of attempted second-degree murder. On the voluntary manslaughter charge, however, the jury was deadlocked, and that's the one that they would go and have the retrial on. Anyway, that's the charge that now his attorneys are saying is beyond the statute of limitations. So what will we wait and see? So the charges where he was found not guilty, there was no statute of limitations on, but under the Tennessee law, the manslaughter carries a statute of limitations. Now, he was indicted in 2022, 11 years after Karen's disappearance. Karen was reported missing on October 30th, 2011, 3 weeks after filing for divorce from David. Now, the mother of four had gone to a Halloween party earlier that night, and David told police that she had left the party earlier to pick up their daughter from a slumber party. Karen's car, which had a shredded tire, was located near the home. Her purse and the Halloween mask were in the vehicle as well. Now, prosecutors allege that David was the last person to see Karen alive when she returned home from the party, and her body was located 6 weeks later by hunters on December 10th in an abandoned cemetery. The autopsy report stated that the cause of death was blunt force injury to the head. But by the time that David was arrested in 2022, he had remarried and relocated to Birmingham, Alabama, and there he also faces separate charges in Alabama related to stalking his second wife, who has since divorced him. Seems like a real nice guy. Anyway, after both sides presented their argument, the judge punted. He said he's going to take it under advisement and try to have an answer for everybody by the next court date on July 30th. Now, here's the beautiful thing about statute of limitations for the defense. You don't waive it if you don't raise it. You can raise it at any time. So it wouldn't have been a smart argument to make basically early on. The other charges did not have a statute of limitations, but he was found not guilty of those. So those go away. Now the one charge remains. Hey, Judge, by the way, yeah, we think he indicted about 3 weeks too late past the statute of limitations. Ooh, sucks being you, doesn't it, Mr. Prosecutor? You gotta look at those. You always gotta look at that. So anyway, we'll keep an eye on that case for sure. Next on the docket, is Amazon becoming the new post office? Now, I'm not talking about package delivery, so to speak, but remember, had all those things where workforce incidents would take place at the post office and people would say, oh, they're going postal. Is it just me? Maybe I'm just a little sensitive to Amazon. I don't know. But it seems like there's a lot of stuff going on at Amazon shipping centers these days. And anyway, the reason why I bring that to you is there's a case in Minnesota at an Amazon fulfillment center where a employee was arrested and accused of killing his coworker. Why, you may ask? Because there was an argument over a missing flashlight accessory. Now, Mohammed Hared was taken into custody last Saturday and charged with one count of second-degree murder in the slaying of Ahmed Ibrahim Karif. Police went to the Amazon fulfillment center about 4 a.m. on June 29th after they received multiple 911 calls reporting that a shooting had taken place in the parking lot there at the Amazon Center. One of the callers identified himself as Harid and said that he had accidentally shot a coworker. Now, upon arrival at the Amazon Center, first responders located Karif lying face down on the ground between two cars, while Harid stood nearby with a gun in his hand. A third man, identified as Witness 1, had also called 911 and was waiting inside the facility for police. Now, Karif was pronounced dead at the scene. Police then learned that Harid, Karif, and the witness were all colleagues, and they actually carpooled to work together. The three men all had a break about 4 a.m. and agreed that they would all go look for the flashlight in the car, and Harid told police that he put the gun back in his waistband while they searched. Anyway, Harid claimed that when he politely asked Karif to return his flashlight, Karif became very upset and made a stance indicating that he wanted to fight. He claimed Karif advanced on him and threw a punch, so Harid had no other choice but to defend himself. Now, according to Harid, he tried to run away, but Karif chased after him and cornered him, which is when he pulled out the gun and he said, "Stop, man, I don't want to have to use this." But that didn't stop Karif from advancing, and obviously he was shot. Hadid also said, "I don't know if he reached for my gun, but as soon as he jumped on me out of nowhere, I heard the first shot. I don't know if it hit anything else." Harid also told the police that Karif then began strangling him and attempting to pry the gun away from him, which is when the weapon accidentally fired. However, testimony from the witness, which was corroborated by, those security cameras, undercut several of the defendant's claims in his version of the events. The witness told police that when he and the other men couldn't find the flashlight, he suggested they call security to review surveillance footage on the parking lot, but Harid refused. "No, you guys took my flashlight," Harid allegedly said to the other men. "I want my flashlight back. No one's going home today." Harid and Karif then got into a brief physical altercation that the witness broke up. Minutes later, there was a second physical altercation during which Harid took out his gun. And then apparently when Harid pulled it out, Karif tried to grab the gun. Harid shot Karif. The bullet struck the car, and Karif then yelled, "Don't shoot me." According to the Witness 1, Harid fired a second shot at Karif. He then fell to the ground. Witness 1 believed that there was approximately 3 to 5 seconds in between the fired shots, and then the witness ran inside the building out of fear of being shot himself to call the police. Like I said, those pesky security cameras, they're everywhere these days. Anyway, a review of the security camera footage showed that Harid threw the first punch in the men's first altercation, and that at no point during either fight did he attempt to retreat, despite having multiple opportunities to do so. Instead, he engaged in the fight, apparently at 4:09, when the shot fell to the ground, and then he walked away. The autopsy revealed that the bullet entered Karif's chest and struck his heart, lung, and aorta artery. Well, Mr. Harid, you're going to continue to remain in jail on the $1 million bond. Your next court date is July 15th. Mr. Harid, I don't know what went on. I guess we can watch the video eventually, but that would have been a good opportunity for you to keep your mouth shut, because now your version of the events is completely contradicted by the video. And guess what? Your statement's going to make you look like you're not being truthful. Should have kept your mouth shut. And those pesky cameras over a flashlight accessory. Are you kidding me? Next, couple more school employees get in trouble. Can you imagine what these two girls got in trouble for? Please meet Riley Greason and Brooklyn Schuler. They apparently have played important roles in each other's lives, specifically their weddings that they both had within the last 2 years. And now they can also say that they've been indicted together. That's right. A grand jury indicted the two young ladies on 3 counts of sexual contact by an employee or agent in the first degree. The first 2 counts of the indictment allege that Ms. Greason had sex with 2 different male students while employed by the school district. Count 3 was against Ms. Schuler, who is accused of having sexual intercourse with one male student. Now, the grand jury claims the women reasonably should have known all three of the alleged victims were enrolled as students at the time that they engaged in sexual acts with the young men. Now, the indictment is unclear and does not reveal the students' ages or which schools that the students were enrolled at the time of the alleged sexual crimes. The two women were, in fact, arrested and later released on bond. Now, Greason and Schuler allegedly had sex with these students sometime between October of 2021 and January of 2022, which predates both of their marriages. Now, Ms. Greason and Schuler could each face up to 25 years in prison and up to 50 years if sodomy was involved in the alleged sex act with the boys. Then it could be, like I said, up to 50 years. So, it's nice to know when you have those close friends that you share things with. Yes, their weddings, maybe college roommates, and now you can share their indictments together. Nothing brings friends closer. Does it? Does it? I don't think it does. Anyway, if you work at a school, stay away from the students, okay? And students, if your weird, creepy teacher or employee at the school wants to hang out with you, it's illegal, okay? Go tell an adult immediately. It just went off. Where have we heard that before? So investigators in Kentucky are responding to a shooting death where allegedly the gun just went off. Now, this occurred last week, like I said, in Carroll County, Kentucky. So at approximately 8:30 p.m., the police responded to a shooting that had occurred at a gun store. Upon arrival, the police noted that the victim in the store was receiving treatment by emergency personnel for a gunshot wound. The preliminary investigation indicates that the customer in the store was viewing a firearm for sale and manipulating it when a single round discharged, striking the victim, who was apparently just in the store. One store patron immediately attempted life-saving measures. The victim was transported to the hospital where he ultimately died from his injuries. The victim was identified as Chad Wainscott from Worthville, Kentucky. Now, the individual in physical control of the firearm at the time discharged is cooperating with the investigation, and witnesses at the scene have also been interviewed. Now, at the time, based upon statements and evidence collected, no foul play is suspected, and no charges are pending as of yet. I guess it would depend on whether the person knew that the firearm was loaded. How did it get loaded? How did the ammunition get there? It didn't just happen to get there by itself. Obviously, we need a little more information. But you would think someone would be charged with criminal negligence. Would you not think so? Or reckless manslaughter? I don't know. It just went off. Where have we heard that before? Now, guns normally don't just go off. Now, there have been some cases, and the jury just found that a Sig Sauer P320 did, in fact, just go off, and there's been lots of claims of that. But I'm not saying anything because I don't want to get sued by the company. But a jury found that particular situation, that it did, in fact, just go off after many reports of similar type incidents where the company has denied all liability whatsoever. And I may have done a case and had a beautiful collage of my clients saying, it just went off, it just went off, it just went off. So it does happen. It does happen. But it's a gun malfunction normally. Not so much on revolvers. But when sears aren't done right in the little thing, things could slide forward, no safety, it could just go off. Anyway, next on the docket, our dumb criminal of the day. Now, I'm not sure who is the most dumb person in this case, the dumbest person in this particular story, but a Florida woman was arrested for domestic battery after she attacked her boyfriend because he declined to cuddle with her. So when police arrived, they came in contact with Jillian Eugen and her boyfriend. They were apparently arguing because the boyfriend was not interested in engaging in physical intimacy. Then the dispute reignited Sunday morning in the couple's residence after, once again, Miss Eugen continually tried to cuddle with the victim. The man then rebuffed cuddling, according to the police. Miss Eugen then escalated the dispute into a little bit more of a physical confrontation. Eugen then allegedly grabbed the victim's chest hair, scratched his face, bit him once on the forehead, and broke his phone. After being read her rights, Miss Eugen reportedly admitted that she, in fact, continued to touch the victim multiple times after being repeatedly told to stop. That's called harassment. And then there's a domestic violence factual basis if they haven't been involved in an intimate relationship. Maybe it wasn't intimate because he kept refusing. I don't know. Anyway, Miss Eugen characterized the touching as cuddling, according to the police officer's report. Now, she was, in fact, arrested for misdemeanor domestic battery and taken into custody, and she was released upon her own recognizance. But guess what? The boyfriend got the wish because she can have no contact with him. Like I said, I don't know who is dumber. Her for continuing to try to cuddle when the boyfriend didn't want to, and then admitting to the police that she harassed him, or the boyfriend who had Miss Eugen, who clearly was interested in him, and he was rebuffing her. I don't know. Who's the dumb one in this situation? Well, apparently they both are. And Miss Eugen was the only one that got arrested. All right, ladies and gentlemen, that's all we have for you today. I hope you enjoyed the show. Have a wonderful Independence Day, celebrated on July 4th. Best holiday of the year, I must say. So we will bring you our Declaration of Independence show tomorrow. I love it. And have a wonderful day. We'll see you next time. And remember, yes, the Constitution matters.